Many of our businesses rely on reaching out to potential customers through various means. More and more, these communications are being done through electronic means. Almost every business you interact with online has some sort of newsletter or other electronic means of communication that they are looking to send you. When done right, these types of marketing strategies can offer a good way of staying connected with your customers and increasing the lifetime value of those customers to your business. More and more, however, this is beginning to become a problem. I'm sure many of your inboxes are cluttered up with emails from various businesses and services that you are not interested in reading about. Canada was actually one of the worst countries in the world in terms of what we call electronic spam. Up to this point, there was not a unified piece of legislation in Canada that regulated the sending of electronic communications to the general public, making it the only country in the G8 with this distinction. However, on July 1st, 2014, this changed when Bill C-28, Canada's Anti-Spam Law, or CASL, came into effect. Prior to the implementation of CASL, the sending of commercial electronic messages was governed by the Personal Information Protection and Privacy Act, which allowed for opt-out consent for electronic communications. What this means is that a business was allowed to send electronic messages to clients and prospects unless they have specifically indicated that they do not want to be contacted. The new CASL law takes things a step further and requires that recipients opt in to receiving electronic communications. CASL has significantly strengthened the regulation for unsolicited electronic communications originating in Canada. The crux of the legislation is that it prohibits the sending of unsolicited commercial electronic messages unless, and I quote, the person to whom the message is sent has consented to receiving it, whether the consent is express or implied. However, the legislation also stipulates other requirements, such as what must be contained in a commercial electronic message. It is important to understand what qualifies as an electronic message under CASL. This is one of the areas in which Canada's spam law is more onerous than that of other countries. Under CASL, electronic messages include any electronic messages, not just email. For example, this includes SMS and social networking. Technically, Twitter, LinkedIn, and Facebook are caught by these regulations. CASL legislation applies only to commercial electronic messages. Whether a message is commercial depends on whether it would be, quote, reasonable to conclude that the purpose or one of the purposes of your message is to encourage participation in a commercial activity. A commercial activity is defined by CASL as, quote, any particular transaction, act, or conduct, or any regular course of conduct that is of a commercial character, whether or not the person who carries it out does so in the expectation of profit. This is a very broad definition that can catch most business-related activities. A good rule of thumb is that if you're not sure whether a communication is a commercial one, then you should err on the side of caution and ensure that you are in compliance with CASL. There are several broad categories of communications which are either exempted entirely from CASL or which are exempt from the consent requirements. The types of messages that are entirely exempt from CASL are messages between individuals having a family or other personal relationship, or business-to-business inquiries or applications. Commercial communications that have a consensual basis will have to comply with the content requirements but not the consent requirements of CASL. These types of communications would include sending a quote in response to a request for one, facilitating a commercial transaction, providing a warranty, product recall or safety information about a purchased product, delivery notifications for purchased products or services, and finally providing information about the ongoing use of a purchased product or service. The CASL requirement for consent means that you will no longer be able to send messages to prospects or even to existing customers unless you have their consent, whether this consent is express or implied. What this means is that individuals must opt in to receiving electronic communications from your business. The requirement for express consent is relatively straightforward. If someone indicates specifically that they would like to receive communications from you, then there is no issue. What is more complicated is when you can be confident that you have implied consent. The Act says that there will be implied consent in a few circumstances. The first circumstance is if you have an existing business relationship with the person to whom the message is sent. This includes a relationship arising from the purchase of goods, services, or land, the acceptance of a business, investment, or gaming opportunity, or the signing of a contract. In these circumstances, you have 2 years from the date of purchase, acceptance, or signature to send them the message. An existing business relationship also gives implied consent if an inquiry or application was made to the sender by the recipient within a 6-month period before the message is sent. Another situation in which you have implied consent under CASL is the situation in which a person has conspicuously published their electronic address or has disclosed to you directly their electronic address. They have not indicated that they do not wish to receive unsolicited communications, and your communication to them relates to their role or function in their business capacity. Along with consent requirements, CASL also stipulates content-based requirements that can be divided into 2 categories: identification and unsubscribe mechanisms. With respect to identification, CASL requires that the identity and contact information of the sender of a commercial electronic message must be set out in a clear and prominent manner. If the sender is sending the message on behalf of a third party, the sender must identify the person on whose behalf the message is sent. If it is not practicable to include this information in the message itself, it is acceptable to post the required information on a website that is readily accessible by the recipient, so long as access to the website is at no cost to the recipient and the link to the information is clearly and prominently set out in the message. The contact information provided must be valid for a minimum of 60 days after the message is sent. With respect to unsubscribe mechanisms, CASL requires that senders of commercial electronic messages must include an option for the user to unsubscribe. The unsubscribe mechanism must remain in operation for at least 60 days, and an unsubscribe request must be acted on within 10 days. Canada's Competition Act already makes it an offence to include false or misleading information in an electronic message. CASL will amend Canada's Competition Act to make it an offence to provide false or misleading information in the subject line of an electronic message. This means that businesses should be careful about what they say in the subject lines of their electronic messages and make sure that this information is accurate and relates to the content in the body of the email. With respect to enforcement, the Canadian Radio, Television and Telecommunications Commission, or CRTC, will be the agency responsible for dealing with complaints made under the new CASL legislation. One of the reasons CASL is getting so much publicity is because of the weight of the fines the CRTC is authorized to levy. The CRTC has the ability to levy administrative monetary penalties at a maximum of $1 million per violation for individuals and up to $10 million per violation for corporations. The CRTC is also authorized to lay criminal charges for obstructing an investigation of CASL compliance. Finally, there is a private right of action for those who have suffered an actual loss or damage as a result of non-compliance with CASL legislation, though this is subject to a 3-year transitional period. In other words, this right won't come into effect until July 2017. Finally, the CRTC will have the power to start their own investigations or can do so based on a complaint that it has received. Messages originating in Canada being received in the United States are still required to be in compliance with the US's own piece of legislation called CAN-SPAM, or Controlling the Assault of Non-Solicited Pornography and Marketing Act 2003. CAN-SPAM was a leading piece of legislation in its day, but it is relatively outdated now. CAN-SPAM applies only to electronic mail messages, not to all commercial electronic messages as CASL does. As such, CAN-SPAM's restrictions have traditionally been applied only to email messages. Furthermore, the maximum fine for a CAN-SPAM violation is $16,000, so it is not nearly as onerous as CASL. Like the previous Canadian regime, CAN-SPAM only prohibits sending of electronic mail messages to users who have not opted out of receiving said messages. As such, CASL has a much more strict application than those that exist currently in the US. As such, if you are in compliance with the requirements of CASL, you can rest assured that you are in compliance with CAN-SPAM. Many businesses use third-party applications to facilitate their electronic communications. Often, these services have a best practices guide that users can follow. In most cases, if businesses are using the best practices suggested by their third-party service provider, they will be in compliance with the consent requirements of CASL legislation. Services like MailChimp and Constant Contact actually recommend using a double opt-in or confirmed opt-in strategy, in which users must explicitly consent to receiving messages twice. In terms of tips and advice moving forward, I have a few suggestions. First, if you are going to rely on implied consent exceptions, make sure to scrub your lists within 2 years of doing business with a person or 6 months within receiving an inquiry. If you are going to rely on explicit consent, make sure you track the explicit consent that you receive and keep as much evidence as you can. Finally, if you're uncertain whether a message is caught by the CASL regulations, it is best to err on the side of caution and get consent. My name is Jonathan MacKenzie. I'm a lawyer with Aluvion. I work with businesses to help them understand and take advantage of the law. To learn more about how Aluvion can help your business, check out our website at www.aluvionlaw.com.